Hello and welcome. I appreciate you being here. One of my goals with this live is for us in M&A to be able to connect with each other. And although M&A activity has slowed down over the past couple of years, things are picking up, and it's important that corporate lawyers of tech companies stay ahead and be prepared. If you don't know me, my name is Ilanit Appelfeld and I'm the CEO of Appelfeld & Co. I'm based in Israel and I work directly with legal teams and with founders of tech startups to increase company value through IP and prepare for the next stage. This specific event is more for lawyers, but you will still benefit if you're a founder or manager because you can understand what your lawyer is doing and see the bigger picture. The focus of the talk today is how to approach IP when helping your clients plan and prepare for M&A transactions. And the reason I'm doing this event today is I see a lot of lawyers focusing only on patents, or they ask to receive a list of patents as the only form of IP. And patents are just not enough anymore, especially in today's landscape. And if you don't have the tools to talk about your client's IP, then they're going to be at a massive disadvantage. If your clients are fundraising, if they're filing an application to the Innovation Authority, or if they're thinking of being acquired, they need to identify and present all of their assets that create value for them as a business. And we've identified this in our business, which is why instead of just concentrating on patents, we're now working together with lawyers and founders to justify their value and their valuation by uncovering other assets. And that's why I'm doing this event, because more lawyers need to understand that they can elevate their client's IP as well as their own practice and add greater value to their clients and secure stronger deals by expanding their focus beyond patents. Now, if anything that I say resonates with you, just message me on LinkedIn. And let's start with a brief overview and introduction to set the stage. I'll talk about the crucial role of IP in M&A, the common challenges that we see when it comes to IP and M&A transactions, and finally, how we address these challenges and how you, as a legal rep, can better prepare your clients for these transactions. So let's dive into some encouraging data to set the stage. We're seeing early signs of recovery in the first quarter of 2024. In Israel, the tech sector is seeing an increase in fundraising and in investment rounds. In the US, we saw NVIDIA's acquisition of Run AI, and also there's an increase in large M&As during this first quarter. Looking ahead to 24 and 25, we will probably hear about companies buying other companies, not only to expedite development and reduce investment in R&D dollars, but a big part of it will be about securing talent. And both these strategic assets, technology and talent, are very much connected to intellectual property. So IP really sits at the core of these transactions. And it's crucial because it directly impacts how attractive and valuable a company is seen to be. So it's not just about the tech or the people, it's about how those elements are protected and leveraged through IP. So what's the role of IP in an M&A deal? The overall objective is to transfer value to the acquiring company, to the buyer. Every business holds some form of IP, and every M&A transaction includes a transaction of some form of IP. And in any transaction, the transfer of value happens through several key stages. We identify the various IP assets that are being bought. We do the due diligence of the identified IP, and then we transfer ownership. So whichever way you look at it, whether it's registered or not, IP plays a significant role in the puzzle of M&A deals. And there are some common issues that I'm seeing over and over. The first issue is this. If you represent a company being acquired, you will be asked by the legal team of the acquirer buyer to produce a list of registered and unregistered IP. So it's very easy to ask the patent attorney for a list of registered IPs such as patents and trademarks and send this list to the buyer's attorney. But how do you come up with a list of other unregistered assets, just such as know-how and processes and assets relating to your client's data that haven't been registered? Now, the second issue relates to your client's awareness. Your clients are continuously developing code and products and adding value to their company, but they may not even realize that a significant portion of their developments amounts to IP. And sometimes they don't even realize what their competitive advantage is. And if your client is not aware of their IP assets and give you an incomplete list, then there is no way that you're going to be aware of these assets. And if you don't have the complete picture about what your client's IP is, then you will not be able to use these assets as in the negotiation or as the negotiation unfolds to disclose these assets into the agreement.
אנחנו בלייב.
Yeah, I'm just... And there are some common issues that I'm seeing over and over. The first issue is this. If you represent the company being acquired, you will be asked by the legal team of the acquirer to produce a list of registered and unregistered IP. So it's very easy to ask the patent attorney for a list of registered IP, such as patents and trademarks, and send this list to the buyer's attorney. But how do you come up with a list of other unregistered assets, such as know-how and processes and assets relating to your client's data that have not been registered? The second challenge relates to your client's awareness. Your clients are continuously developing code and products and adding value to their company, but they may not even realize that a significant portion of their developments amounts to IP. They sometimes don't even realize what their competitive advantage is. And if your client is not aware of their IP assets and they give you an incomplete list, then there's no way that you, as a corporate lawyer, will be aware of these assets. And if you aren't aware of these assets and you don't have the complete picture about your client's IP, then you will not be able to use these assets in the negotiation. You will not be able to represent these assets in the agreement, or even know what the risks are relating to these assets. Now, the third issue relates to the expectation of the buyer or the investor. As the deal progresses, the buyer expects to see another layer in the business that they haven't seen. With technology companies, they want to see the know-how and talent of the people in the company. This layer is usually not revealed to everyone. It is not included in the patents, so it's not published, and it touches more on the company's competitive advantage. We spoke about talent and how acquirers are going to want to secure talent. Some of this talent is reflected in the internal processes they develop, which are crucial to the company's operation. And if the company doesn't do the background work on mapping out this layer and protecting it, then the expectation of the buyer will not be met. And remember that when a buyer looks at the target company, they already have some kind of prior relationship with the company. And they expect to see the depth of the know-how as the relationship matures. They want to see what the talent of the company have come up with, and they want to see the bigger picture and the deeper picture. And lawyers are going to be expected to be very clear about what these assets are. And this scenario, by the way, can easily be prevented, as you will see in a second. The fourth issue arises when you are unable to demonstrate that your client has implemented an IP protection plan around these assets or a protection mechanism to close the sensitive IP container. And when you can't show that your client has a process to protect their IP asset, it signals to the acquirer that your client is not on top of their IP management. And this is more problematic than you think. For example, let's take visits to your client's offices. Clients who become potential buyers usually come at some stage to see the company, your client, and to see where the magic happens. Now, it's really important for you to coach your clients to say the right things and signal that they're on top of their IP. For example, they may request their guests not to take pictures in certain restricted areas. They want to maintain clean whiteboards and keep records of their visitors. So all these issues start with not being able to demonstrate that there are more layers to the business than the patents filed. So how do you address these challenges? Well, we team up with you and your clients and do some digging to uncover their critical hidden assets of unregistered IP. This is what we call the asset mapping stage. Then we'll build a process around these assets called an IP protection plan and get everyone on board with what it means for the people in the company to work in a company that has valuable assets. And after that, we do a short training to the people in the company to update them on what was done and how it affects their day-to-day. The result is an innovation catalog and an IP protection plan. The innovation catalog doesn't just list the patents, but a dynamic portfolio of the assets and a culture of IP awareness and protection, which is critical for M&A transactions. From the way your clients manage their social media presence to how they host visitors, from HR interaction with departing and incoming employees to how the company CEO articulates the company vision. Every transaction is an opportunity to demonstrate the strength and scope of your IP assets. And by preparing in this way, we ensure that when a buyer does take a closer look, they see a company that's not just on top of their IP, but that has integrated IP protection into its operations. And this approach sets your clients apart in a very competitive M&A landscape. And when you as a legal advisor are able to demonstrate a more complete IP picture and a solid IP protection plan, you will be able to strengthen your client's position, which will lead to more favorable terms in the M&A negotiations. You'll be able to minimize potential drama and deal breakers, and you will be able to enhance your client's competitive advantage, which will attract more potential investors or buyers and set your client apart in the marketplace. You will also be able to negotiate from a position of strength and achieve better outcomes for your client. Of course, you will increase the likelihood of the deal being a success and closing, and of course, bring more business for your firm in providing, the legal support for your clients, not to mention client loyalty and repeat business. So 2 things to conclude. At the end of the day, clients and potential buyers understand that patents reveal a very small part of the business. They understand that most of the value lies in the know-how, in the team's talent and ability to develop more assets. And not being ready with the right story puts your clients at a disadvantage. By encouraging your client to recognize and present their know-how and data assets, you will strengthen your client's competitive advantage, and you will also be better prepared for the next round or acquisition. And second, you as a legal advisor are really the perfect partner to guide your client to look beyond patents and achieve better outcomes, because you see much more in terms of where the company is, you already have a good understanding of the business, so supporting your client in identifying their IP will be intuitive for you. Your clients trust you to guide them in the right direction too. Thank you very much for being here and for your attention. If you have any questions or would like to connect, please feel free to reach out to me on LinkedIn. My next event is going to be for founders and how to increase IP value and company valuation through IP. If you want to be invited and you're a founder or manager of a startup, please let me know. Thanks again for being here, and thanks for listening.